Alright, here we go with Chapter 9, Pre-Trial and Trial. I want to kind of start with the whole concept of pre-trial and what that means. It is super basic. When I'm saying something that is pre-trial, it means it happens before the actual trial. And that's it. So don't think too much into that whole concept of pre-trial. When someone, basically one of their first hearings that they have, the judge will decide whether or not a person can or should be released on bail. A lot of us would think that we have the right to bail because it is in the Eighth Amendment. And to a certain extent, it's true. We do have the right to be considered for bail by a judge. But that does not mean that everybody has a right to be released on bail if they can come up with enough money. Think serial killer or person who might be trying to flee the country. Those are two reasons why someone might not be granted bail, because they are a danger to the community or they are a flight risk, meaning they would not come back. So bail, as you are all pretty aware, probably an amount of money, a certain amount of money or collateral that is given typically to the courts by way of a bail bondsman. And, oops, I didn't mean to do that. And when a person comes back to their next hearing, they get a portion of their money back. So, California, I think October of 2019, we were supposed to stop bail in California, but that did not happen. So that is kind of still working its way through the courts in the state of California, because if you think about it, it's really not fair. If you're homeless or broke, you are very unlikely to get out of money, and if you're wealthy, get out of jail. If you are wealthy, then you would have more of an opportunity probably to get out of jail, not bail, jail. Okay, so amount of bail, the judge doesn't just randomly, willy-nilly pick a number. There's a little chart that they follow where depending on the seriousness of the crime, as to how much the person has to pay in order to get bailed out. Sixth Amendment takes effect as soon as charges are filed, and this is due process. Due process. You have the right to an attorney, you have the right to a speedy trial, you have the right to a jury, and you have the right to confront and cross-examine witnesses. Stuff you've probably all heard before, but this is part of the Sixth Amendment, which protects your due process rights. So you have the right to have an attorney. Anytime you may lose your freedom, you have the right to an attorney. And that starts from the very beginning, Miranda, at the time of questioning. Okay? So you have the right to have an attorney present throughout the court proceedings. Are they exceptions? Yeah, there are exceptions. Typically, you still have the right to have an attorney, but in some places, if there's only a fine imposed and you are not going to lose your freedom, you may not have the right to have an attorney. And if you choose not to be represented by an attorney, you can do that too. I don't know why you would, but anyways. You do have the right to a speedy trial. You're probably wondering, why do trials take so long? Well, typically it's because the defense counsel, the person representing the defendant, has asked for a continuance. If the right is violated, the defendant will go free regardless of guilt. So let's say I am on trial for murder and my trial date has come up and the star witness did not appear. Can the prosecution at that point ask for a continuance? They can, but I'm getting out. So basically, no, I have the right to have a speedy trial. I can waive that right as a defendant, but the prosecution cannot waive that right. What about the victim? Okay. What rights do victims have? Victims do have rights, and more as time goes on, but a lot of times the victims are forgotten. You do have the right to have a jury trial, which means a jury of your peers. I'm doing little air quotes when I say a jury of your peers. We're talking about a group of people that is representative of the community in which you live. Some people don't want to have a jury trial. They want to have the judge hear the case. That's called a bench trial. what are some reasons why you might not want to have a jury? Well, consider a case like child molestation. You are before the courts for raping a child. Okay, sorry, I had to take a quick break there because the dog jumped up here. Okay, so I was talking about a bench trial. So child molestation. You are accused of raping a child. Imagine the look on the jury's face when they hear those charges. Regular, everyday, average people like you and me, you know, a soccer mom and whoever else, they're going to be horrified. Unfortunately, or fortunately, judges hear about these horrible types of crimes all the time. It's not new to them. So the whole shock value and emotional issue, it kind of is set aside when a judge hears the case. So that's kind of why. I'm sure there's some other reasons too, but that's a really good example of why someone might have a bench trial. Okay, change of venue. You may remember Scott Peterson. Scott Peterson was a youngish, I don't know, 20s, in his 20s, guy who was alleged to have killed his pregnant wife, Lacey Peterson, up in the Bay Area in Northern California. And first she just went missing, with the air quotes, missing, and he was all over the news. Oh, please bring Lacey back. I miss her, blah, blah, blah. And then they found out ultimately that he was the one that killed her and dumped her in the bay. But the community where he lived were so invested in the story because it was this missing pregnant woman, and she was just beautiful, had this gorgeous smile, and just kind of like lit up the news media, and it was a big deal. So he felt like he wouldn't be able to get a fair trial there because so many people knew about the case. So he asked for a change of venue, which is just a geographic location. And he got that, and I believe his case was actually heard up in Mariposa County. Excuse me. He was convicted anyway, and he is on death row right now, although we don't have the death penalty right now. But anyways, he's on death row right now. What else? Hearsay evidence. I'm just going to stick with this whole any statement made by a witness that is not based on that witness's personal knowledge. So I can't testify that a friend of mine told me something. I can only testify to it if I actually witnessed it. There are more than 30 exceptions to that rule, so it's a really tricky one. Clearly this is not a course to talk specifically about hearsay evidence, but we could literally do an entire semester on just hearsay evidence. So, but yeah, hearsay, there's the definition for it. Double jeopardy. The Fifth Amendment states that you cannot be tried for the same crime twice. So think O.J. Simpson. O.J. was tried and acquitted, found not guilty, of the murder of his ex-wife, Nicole Brown Simpson. So let's just say, for example, that O.J. is looking for some money because he is now having hard times, and he really needs some money. And he calls up Oprah and says, "Hey, Oprah, I want to do an interview with you, and I want to tell you what really happened, and that I really did kill her, and I want you to pay me $3 million so I could do that interview." If he did that and came out now, after he's been acquitted, did the interview, and said, "Yes, I killed her, and I killed the guy too," could he be tried for that crime again? Absolutely not. Absolutely not, because he's already been acquitted of that very crime. Okay, makes sense? So there's a kind of a side note here, where a situation where you could actually be tried twice, and I'm going to use Bill Cosby as the example for that. So Bill Cosby was tried for sexual assault rape. And at the end of the first trial, there was a hung jury, meaning the jury could not come to a decision. So the judge ordered a mistrial, meaning the whole trial was basically invalid and they had to start all over again. So he was tried again, and he was convicted the second time. Now, the only reason that's not double jeopardy is because there was no outcome the first time. There was no acquittal the first time. There was a hung jury. So that makes it different. Here. All right, so that pretrial process. Typically, it's going to begin with a person being arrested and booked for whatever the criminal behavior is. What do they do in booking? They identify, they fingerprint, and they classify an offender. We'll talk a lot more about classification when we get to the corrections section of the class. The prosecutor will review a police report and decide whether or not he or she is going to file charges. If charges are filed, then the first hearing that defendant has is called an arraignment hearing. And typically there's a mugshot of Emil Hirsch. Typically at his arraignment hearing, a defendant will enter a plea: guilty, not guilty, or no contest. So guilty, admit to the charges. Not guilty, denies the charges. No contest is a little bit different. No contest is basically saying, I will accept responsibility for those charges, but I'm not going to allocute. I'm not going to tell you in court what it is that I did. So why do we need this? Well, a lot of times, people will use a no contest plea to protect themselves against a civil lawsuit. Let's say I killed somebody. If I admitted it or pled guilty to it in court, then when the victim's family wants to sue me civilly, I have no defense. I've already admitted in criminal court that I did it, so I'm going to be on the hook civilly as well. So this is kind of a way for a person to take responsibility for an offense. It's the same consequence as a guilty plea. So if you plead no contest, your punishment will be exactly the same as if you plead guilty. Okay. Okay. We talked a little bit about grand juries already. A grand jury, their responsibility is to decide whether or not there's enough evidence for a case to go forward. That exact same thing happens at a preliminary hearing. A preliminary hearing does the same thing as what a grand jury does, and that is decide if there's enough evidence to go forward. A preliminary hearing is a little mini trial that takes place in front of the judge. After the judge hears this little mini trial, the judge decides if there's enough evidence to go forward at that preliminary hearing. Okay, so grand juries and a preliminary hearing, they both do the same thing. Grand juries are not like locally as common. We don't have a lot of grand jury indictments or in like in the Fresno area. There is a grand jury here, but we don't use it that often. So yeah, same purpose, blah, blah, blah. Discovery. Discovery is a fancy word for evidence. So when there's a trial, both sides are required to share their evidence. So the prosecution and the defense both have to share their evidence or discovery with the other side. There are a lot of different things that could be addressed at a pretrial motion. Suppression of evidence, change of venue, change in plea, all that kind of stuff. So there's a bunch of different things that could happen at that, let me go back here, at that pretrial motion. Plea bargaining is also probably something that you've heard of. This is when the defense and the prosecution get together and work out a deal so that they don't have to go forward with a trial. Typically, the prosecution is going to drop a charge or reduce a charge in order to get someone to plead guilty. And why do we do this? Because we simply do not have enough courtrooms to try all of the cases that go through the courts. The percentage of cases that actually go to trial is something like 3 to 5%, which means 95 to 97% of cases are resolved by way of a plea bargain. Okay? Blah, blah, blah. I'm going to kind of skip that. Influenced by lawyers, blah, blah, blah. Victims, yeah, this is the tough part of plea bargaining. Depending on how serious the offense is, the prosecution really should talk to the victim and their family about it before offering a deal, but it just doesn't always happen that way. So victim has zero power to deal with that. Criminal trial, due process, substantive due process, we're going to kind of skip this. A defendant's rights need to be protected in court. It's really what due process means. We have something called a burden of proof, and you've probably heard this before. The burden of proof in a criminal case is beyond a reasonable doubt. Beyond a reasonable doubt. It is the prosecution's responsibility to prove beyond a reasonable doubt that a defendant committed a crime. It is not the defendant's responsibility to prove he did not do it. I hope that makes sense. So think about that and rewind that if you want to hear me say that again, because it's important. When you go into court, the defendant is innocent until proven guilty. This guy was wrong. I think that's that. I can't remember the name of that show. But didn't he end up killing somebody anyway? Anyways. Standard of proof. Beyond a reasonable doubt, you'll see right here. Beyond a reasonable doubt is the standard of proof or the burden of proof in a criminal case. In a civil case, it is preponderance of the evidence. So this is a lot less certain than this. Okay, and we're not even going to talk about that one. Burden of proof, burden of proof, burden of proof. Beginning of a trial, a jury is chosen and sworn in. They swear to be fair and all that kind of stuff. Each side, prosecution and defense, gives an opening statement. They basically introduce the case from their perspective and give their version of what they're going to prove in court. Then the prosecution will lay out their case. They will call all their witnesses, show all their evidence. And the defense attorney will show all of their evidence after the prosecution rests his case. And we're not even going to go into this, but if you want to read that, it's interesting, but it's just too much. After everybody's rested and given their closing statement, which is basically when each side will kind of, I like to say, like wrap it up and tie a bow around it and say, this is what we just proved to you. We expect you to, find the defendant guilty. And then the defense will say, no, they didn't prove anything, and we expect you to find him not guilty. Okay. And the judge gives the jury instructions. That's called charging the jury. The jury deliberates, and they come back with whatever their decision is. We talked a little while ago about Bill Cosby and the fact that the first trial he had, there was a hung jury. The jury could not reach a verdict. That can happen. A hung jury is when a jury is unable to reach a verdict, and the judge will declare a mistrial. And that's what happened in his case. And then the prosecution tried the case again. Sometimes deliberations take days, sometimes minutes, sometimes hours. Just depends. She's making a closing statement. Verdict is read. Oh. And in certain cases, death penalty only, juries are involved. So juries are only involved in death penalty, in sentencing for death penalty cases. Oh, blah, blah, blah. There's a bunch of stuff and key terms. All right. I try to make that as short as possible. Oh, my dog is